and I can get started if everyone else is ready to go. Yep, I'm getting some nods around the video screen.
I'm just trying to hint to whoever I need to hint to. You're very loud. It's like being in an Anita Green concert.
Well, there's nothing wrong with that. Sorry about that. Well, thank you. Well, I declare open this public hearing of the Senate Legal and Constitutional Affairs Legislation Committee Inquiry into the Administrative Review Tribunal Miscellaneous Measures Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders, past and present. I would also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. I'm Senator Green, I'm the chair of the committee, and hopefully my camera will eventually start working, but otherwise I'll be joining on video conference today. The Secretariat understands that Senator Scarr is in person in the room there in Canberra. Senator Antic is joining via video teleconference. Senator Ghosh and Senator Polley are also joining us via video conference, and Senator Shoebridge will be joining us at a later time. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence. This is described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones and to assist Hansard to record proceedings. Mobile phones and other electronic devices should now be switched off or turn to silent mode. Senators, I now welcome representatives from the Migration Institute of Australia. Thank you for taking time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, would you mind please stating your full name and the capacity in which you appear today?
You might be on mute.
Yes. Ms. Markey, are you there? I am sorry about this, Senators. This seems to be a new online system. I'm not really familiar with whether it's...
Okay, so just from my perspective, Chair, we did see Ms. Markey, but now she's dropped out. Hang on, here she is. She's back. Ms. Markey, can you hear us? Ms. Markey, can you hear us? I don't think she can hear us, Chair.
No. Okay.
She's not looking at us.
Maybe we'll just maybe we'll just suspend the hearing briefly, and if broadcasting could suspend the hearing so we're not broadcasting publicly. that's okay with you, Senator Scarr, we'll just resume the hearing. Thank you, broadcasting. You'll need to let me know because I can't tell from here if you have resumed. Yes, we have resumed. Thank you. I now invite representatives from the Migration Institute of Australia. Ms. Markey, thank you for joining us. Apologies for the technical issues. Do you have an opening statement that you'd like to make before we go to questions from senators?
Yes, sure. It's just a short one. I'd like to thank the committee for inviting the Migration Institute of Australia to appear here today. The MIA is a premier professional association that represents the registered migration agents and immigration lawyers who represent the clients who are the centre of these discussions today. My name is Bronwyn Markey. I appear in my role as Senior Advocacy Manager with the MIA. I must apologise for my colleague, Mr. Ruben Saul-Yankee, who is our national president, but has been caught somewhere between here and China on a plane and has been unable to join the video conference. I'd also like to note that Mr. Yankee would have been addressing any of the more practical questions, so I hope...
The conference is now in silent mode.
Ms. Markey, are you there?
The conference is now in talk mode.
Great.
Sorry, yes. Okay.
You just dropped out for a minute. Thank you.
Yes, okay, so I'll just go back. I would also like to note that Mr. Yankee would have been addressing any of the more practical questions, so I hope I can do justice to my inquiries. As the MIA did not make a separate submission to this inquiry, and we believe that we have been invited to appear on the basis of previous submissions we've made to the Social Policy and Legal Affairs Committee, I'd also like to just say to some extent I might need to confine our answers to the issues raised in those submissions, but I'm happy to take any questions on notice. The MIA strongly endorses the creation of the new Administrative Review Tribunal and believe that it will enhance and strengthen the legislated objectives of providing a new federal review tribunal that is accessible, proportionate, fair, economic and informal. In the MIA's previous submissions, we have argued for the standardisation of appeal lodgement times and processes. This has mainly been achieved. However, the MIA very much supports our colleague associations who have made submissions to this inquiry that Section 347 and 348 that provide only 7 days to allow for those in immigration detention to lodge a properly made application. Those in immigration detention face additional barriers to lodging and preparing for merits review, including difficulties in accessing representation, documents, language and literacy issues and resourcing. The MIA would support the standardisation of the appeal term for those in immigration detention to 28 days. Thank you.
Thank you, Ms. Markey. We'll go to questions now from senators, and thank you for giving us that context about the questions that you'll be able to answer.
Thank you.
Senator Scarr, do you have questions for Ms. Markey?
Yes, Chair. And Ms. Markey, I'm just mindful of the fact that given your very helpful introductory statement, there might be a few areas which fall into the practice domain, which make it a bit more difficult for you. So just feel free to take on notice anything which you'd like to discuss with your colleague, and feel free to make a written response.
Sure.
The first question I just want to ask is, from your organisation's perspective, to what extent is this bill actually changing the situation as opposed to simply continuing what is already the practice in relation to the time which people have in detention to make applications? So I understand the point about the time limit and the challenges, but the question I have is in relation, we've set up a new system, obviously with the ART, replacing the AAT. There have been a whole host of changes made. in relation to this time issue, to what extent has it changed what was the practice or what's currently in the practice until the new system comes into effect on 14 October? So to what extent, if I can put it another way, to what extent are the concerns that you're raising really concerns with respect to the current system, and bona fide as they may well be, but not really being changed by the transition to a new system? These are existing issues. Does that make sense?
Yes, absolutely, mate.
The conference is now in silent mode.
No.
The conference is now in talk mode.
So, yes, I understand exactly what you're saying. My understanding is that the what has been put into the new ART, the process and the procedures are very much the same as the previous in the AAT, apart from the fact that the IR changed. So the factor of 7 days hasn't changed from either system. So this is, I suppose, addressing an issue in the old system. I think that's what you're asking.
Yeah. So from your perspective, is it fair to say this was an issue under the existing system, and the concern that is being raised is this issue hasn't been fixed in the new system, from your perspective?
Yes, exactly.
Okay. All right. Understood. And again, I'm not sure practically if you can answer this, but I understand the point around the position of someone who's in detention, issues obtaining access to resources, issues understanding processes and procedures. To the extent that an application has to be made, how extensive is the material that's required to be lodged in the first instance to actually make that initial application? Because presumably under the current system you lodge a form, there's a prescribed form that needs to be lodged, but I'm interested to know, and again feel free to take this on notice, as to the volume of information that's required at that initial stage of simply making that initial application, just to give me a sense of what are the logistics involved.
Look, I will have to take some of that on notice, but I'm also pretty sure that some of the following witnesses will be able to give you very detailed information on that. But I can give you an example of the fact that these people in immigration detention, there have been some cases where information has not been passed on to them about their rights, or time has been taken to get that information to them. So that 7 days of actually being able to lodge has been, drastically reduced for them, in effect. So at the moment, that's basically all I can.
Okay.
So well, it's an access issue, particularly.
Okay. Well, I might. That's very helpful from my perspective. Interested if just to give you an opportunity to provide any comments or feedback you have in relation to the submission from the Attorney General's Department, which is available and which Secretariat can provide you. So keen to provide the Institute with an opportunity just to respond to the arguments which are made in the Attorney General's Department submission.
Yeah, more than happy to do that.
Okay, thank you very much. Thanks, Ms. Markey.
Thank you.
Thanks, Senator Scarr. Senator Ghosh, do you have questions?
Sure. Thank you, Senator. Thank you, Chair, and thanks to the witness for being here. I want to pick up on something that it's probably a broader question, but it's around part of your opening statement where you indicated a need for the system to be economic and proportionate, and our migration system always needs to balance those concerns about efficiency, timeliness, and economy with obviously our obligations and our need to process applications as and when made. Taking a big step back, do you have any further suggestions or measures that you would like to see implemented that would assist in achieving that balance or some of those goals?
Do we go with the broader one of resources?
Okay.
The greatest issue that we see from our members and from clients is the time it takes for applications to get through the system or to get to hearing, to be decided. And I know there's a lot of this in the media at the moment, and it was also included in the Christine Nixon review into exploitation of the system. That resourcing and timeliness of application assessment and hearing is probably the largest one. But as you say, we have to balance the economic situation.
Do you have a... Sorry, don't mean to cut you off. Please continue.
No, sorry, I was going to just add, though, that we were very supportive of the changes around other processes in the new ART about things such as the recruitment and appointment of members. We saw that as really improving the transparency of the operations as well. Thank you.
Thanks very much. And in terms of elaborating on some of that broader optimism as to the changes from the abolition of the AAT and the establishment of the ART, are you getting feedback from any of your members and stakeholders about their views about that transition and the various changes that have been made?
Yes, we do get feedback. We get a lot of feedback about things, but I don't think I could say that we've had any particularly general negative feedback from members about it. I think overall this is seen as a positive move. There are some issues within it, such as this one about the 7 days, but I think many of the other things that have been made have been viewed very positively. Many of the other changes, I should say, have been viewed positively.
Okay. And have you got any feedback in relation to the imposition of fees under the Act?
Sorry, I didn't mean to cut you off there. Yes, this is an issue for us, that the fees in the other sections that are where the appeals can be made, like Centrelink and FOI and all of those, the fees for applications are at least half of what we are charged for our clients in the migration and refugee area. And it's a lot of money. It's getting up close to $4,000 to lodge an appeal. Now, it's fine to say, oh, well, if they win the appeal, they'll get half of that money back. $2,000 is still a lot of money for somebody, particularly if it's a humanitarian appellant, to find. That would be...
just to clarify, yes. That's the merits appeal process, or is that a judicial review appeal?
No, that's a merits appeal. So it's very expensive.
Okay. Thank you very much. Sorry, I didn't mean to cut you off again.
Again, I'm sorry. It's really hard on the phone. Of course, there is a hardship provision, but it's only half of that. So they've still got to fork out. They've still got to find $2,000 to even get an appeal up and running. So that would be, I think, a major thing that we would like to be examined, and why it is so much more expensive in the migration and refugee area than it is in the other divisions. I understand that they have other processes in there, but some of those are also more, you'd say, costly, like having conferences and things like that. So they're time costly and would be costly to the staffing of those. So we don't really see the difference between the two of them and why our fees are so high. Thank you.
Thank you very much, and thank you, Chair. Those are my questions.
Thanks. Senator Shoebridge, do you have questions? I just, given you arrived a little bit late, we had some technical issues at the beginning, which meant we were running a little bit behind. But if you have some questions for this witness.
That'd be good, Chair. And I saw from the chat and I saw the technical issues. And
We tried our best,
Yep.
but we're here now.
I suppose to go to the issue about the impact of fees that you see on the people who come to you for help. Can you describe what that impact is?
Look, there's all sorts of clients that come for, all sorts of different visas. So if you've got somebody, maybe it's a business visa or it's an employment visa, it's very interesting. Is it possible to just, wipe that application and is it cheaper to relodge a new application with Home Affairs, or is it better to appeal a decision? So that decision is made very, very often in those areas where, for example, a business has been refused to be able to nominate an overseas skilled worker. Is it just better that we spend the money, put in a new application and deal with it that way, rather than try and fight it through appeal, which is likely to take, apart from the cost, 2 years maybe to come to actually get to hearing. And there's all sorts of other issues, changes in the businesses and things that could happen in that time. For humanitarian and protection visa people, the cost is huge. A lot of these don't, if they're temporary visas, they don't have access to legal aid. They might need to find a pro bono operator. They use, a sort of more manifest.
How much are we talking for the fees for somebody who can't work, doesn't have work rights? What sort of fee are we talking in the humanitarian space?
No, the humanitarian, for actual visa application fees, do you mean?
For a review fee.
Oh, no, the review, okay, so visa application fees are often free, right, or quite a small amount. I haven't got it off the top of my head because it changes in July every year, but my understanding is it'll be coming up around $1,800, $2,000 for one of those sort of people under financial hardship to actually apply.
Yeah, and without financial hardship, it's about 3.5 or so. Is that right?
It's 3.5. It's getting closer to 4,000. Yes.
Yeah, and if you don't have work rights, that is can be impossible.
Well, yes, absolutely. If you're not working, or there have been some changes in legislation that might help with that a little bit. But yes, it is. Or you're a family, or you're a partner, or you're an aged parent. That is, the cost is a huge consideration. And
under these changes, that some suggest that what these changes mean are if you don't pay your fee, then the application can become invalid.
That's always been the case.
Yeah.
That's always been the case. Yeah.
And what about the provisions that say unambiguously that if you don't bring your review application within 7 days of an adverse decision on a protection matter, that it's invalid? What do you have a view about a 7-day time period?
Yes, I think and this is in conjunction with the other witnesses, such as the Refugee Legal Centre and ASRC that are here today. Yes, I think 7 days is a very short amount of time to try and get some sort of application together, particularly when you're in detention. You may not know your rights. You might not have the literacy or the language to understand your rights. As I said previously, there's been cases where the person in detention has not had that information passed on to them in a timely manner, and so those 7 days have gone. The tribunal does have the capacity to accept it after that time, but that then becomes another whole application to try and get around that barrier.
Well, on one view, and some of the submissions make it clear that this puts in a mandatory 7-day time limit and makes it, that's what this bill does. It makes it express and mandatory and says if you don't meet the time limit, the application is invalid and the ART can't consider it. That seems to be a new harsh approach.
No. That's always been the case. That's been the case with any application that's made. Previously, with a variety of time limits, 21 days, 28 days, 7 days, and that's always been the case.
We'll save for the High Court ruling otherwise in the Miller case, which this. Yeah. I mean, the High Court has said, contrary to what you just put, that if the application is in some ways not perfected, that it's still a live application. This law seems to be in part to try and reverse that beneficial decision of the High Court in Miller and make these matters mandatory and bind the tribunal's hands. Is that your reading of it?
We've always considered them to be mandatory, and it's quite unusual to go outside of that, even with the other tribunals, to have that overturned. So I could ask some of our legal
that would be helpful.
Legal members on that.
And maybe because of time, if you could take on notice what the impact of this legislation will be in terms of the Miller decision, which provided a beneficial interpretation for applicants. Yeah.
Well, the other side of that, of course, is as well that, that then if they're refused to have the application accepted, then they have to go to judicial review to try and have that addressed. That then becomes another cost on top as well.
Yeah, if the end result of this legislation is a bunch of hard and fast rules are applied at the tribunal level and that drives a whole lot of people into the federal court, it's hard to see who wins from that.
Yes, exactly. Yep.
And I assume costs and delays for both sides ratchet up once you go from the tribunal to the court. Is that your experience?
Yeah. Yes, definitely. That's most definitely, yeah. And I know that there are some with the federal courts, but it's a very minor number, is my understanding, because of those costs and the impost of those.
All right. Thanks, Chair.
Thank you very much, Senators, and thank you, Ms Markey. Apologies again for those technical issues at the beginning, but we appreciate your time. We will give you a date to return those questions on notice to us from your organisation. And would you apologise again to Mr Saul, who we weren't able to talk to today, but he might be able to contribute to those questions on notice. So thank you for your time.
I'm sorry, thank you very much. Thank you very much. Goodbye.
Thank you. I now welcome representatives from the next panel of witnesses. Today we're joined by the Australian Asylum Seeker Resource Centre, the Refugee Advice and Casework Service, and Refugee Legal. I understand each witness is joining us by video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I'm going to go and I'm asking for each witness for the Hansard record, if you can state your full name and the capacity in which you appear today. And we can start with the Asylum Seeker Resource Centre. I think Ms Dixon is possibly on the line there joining us.
Good morning. Are you able to hear us?
Yes, we are. Fantastic.
Wonderful. Thank you very much for having us. My name is Hannah Dickinson. I'm the Principal Solicitor and Head of Legal at the Asylum Seeker Resource Centre.
My name is Rachel Saravanamuthu. I'm the Legal Policy Lead at the Asylum Seeker Resource Centre.
Thank you for joining us today. We'll come back to you for an opening statement. The Refugee Advice and Casework Service also joining us via video conference today. We just get your name for the Hansard record.
Yes, hello, good afternoon. My name is Ahmed Sawan. I am the Supervising Senior Solicitor at the Refugee Advice and Casework Service.
Thank you very much for joining us. And the Refugee Legal Centre.
I'm appearing as the head of policy solicitor.
The noise going on.
Sorry. Thank you. Sorry, Ms. Rahimi, I think it is. Your audio is quite disconnected, just to give you a bit of a warning about that. It might be something you can fix between now and us asking you lots of questions, but we'll go to the Refugee Legal Centre as well. Sorry, Mr. Mann.
Yes, so it's David Mann, CEO and Principal Solicitor of Refugee Legal, and I'm with my colleague.
Priscilla Jameson, Senior Solicitor, Refugee Legal.
Well, thank you all for joining us. We appreciate your time. My apologies, you can't see me. We're having a bit of a technical issue today, but we're joined by senators via video conference and in the room. Before we go to questions from senators, I'd like to ask if any organisation has a brief opening statement they'd like to make, and we can go through the same order again if that's helpful with the Asylum Seeker Resource Centre to start with.
Thank you. I acknowledge the traditional owners on whose lands we meet, in particular the Wurundjeri people of the Kulin Nation, where I am located, and pay my respects to their elders past and present. My name is Rachel Saravanamuthu, and I am the Legal Policy Lead at the Asylum Seeker Resource Centre, which is Australia's largest independent aid and advocacy organisation for people seeking asylum and refugees. For over 23 years, the ASRC has been supporting and empowering people during their journey in seeking asylum. The ASRC's legal team has considerable experience representing applicants before the Administrative Appeals Tribunal and witnessing the challenges that refugees and people seeking asylum face in accessing a fair and transparent merits review process. The establishment of the ART provides a critical opportunity for urgent reform to remedy long-standing defects that prevent fair and timely outcomes. Concerningly, the proposed bill undermines the Tribunal's objectives and compounds the additional challenges that refugees, people seeking asylum and migrants face in accessing justice, including language barriers, experiences of trauma and immigration detention. Review before the Tribunal is the last opportunity for a person to have their claims for protection assessed. The consequences of exclusion from merits review are severe, including refoulement, prolonged detention and permanent family separation. The bill proposes to amend the Migration Act to provide that the ART must not review a migration or protection review application that does not comply with strict lodgement requirements, including short deadlines, the provision of prescribed information and documents, and the payment of fees. The bill maintains an unfair and different set of rules for refugees, people seeking asylum, and migrants. These laws will also disproportionately impact the most disadvantaged people in our community, such as women fleeing gender-based violence and people with severe mental health conditions. The ASRC is particularly concerned regarding the impact on people in immigration detention, who only have 7 days to comply with these onerous requirements. People in detention face additional barriers to justice, including due to separation from their families and support networks, serious mental health conditions, and being isolated in remote locations, often for years. People in detention struggle to access legal advice about their review rights and will not be able to comply with the proposed strict lodgement requirements. Our clients in detention do not have the resources to pay for any review application fee, even when they are eligible for a fee reduction to $100, and the ASRC often has to pay this fee for people to access their review rights. It is unfathomable how anyone in detention seeking a migration review could pay over $3,000 within 7 days, which is what is proposed in this bill. I would like to share the story of Kamal about the impact of inflexible tribunal lodgement requirements on refugees. Kamal came to Australia after fleeing serious harm on the basis of his sexuality. Kamal's protection claims were not fairly assessed by the Department of Home Affairs, and his protection visa was refused. He did not have a lawyer and was unaware of his rights. Kamal sought review before the AAT, however missed his deadline by 1 day. Sadly, this is a common situation for people seeking asylum, given the difficulties they face in accessing information about their rights. Kamal's only option was to bring proceedings in the High Court of Australia, and he was represented by the ASRC. The High Court held that the department decision was unlawful. His case was remitted to the department, and after several years, Kamal was granted a protection visa. However, if the tribunal had had the flexibility to accept a late lodgement by a protection applicant, Kamal would have had access to merits review and received a more timely and just outcome. The establishment of the ART is an opportunity to rectify these types of unfair processes. However, this bill seeks to further exclude people seeking asylum and refugees from merits review by imposing onerous lodgement requirements, inflexible timeframes, and lack of extensions. Consequently, many refugees will face the harsh reality of returning to persecution, permanent family separation, and prolonged detention. There is simply no justification to maintain a discriminatory approach towards people seeking asylum, refugees, and migrants. It damages the integrity of government decision-making and the multicultural fabric of our society. I urge the committee to adopt the ASRC's recommendations to ensure that people are not excluded from access to a fair merits review process based on where they are born. Thank you.
Thank you very much. And the Refugee Advice and Casework Service, do you have an opening statement you'd like to make before we go to questions?
Yes, thank you. I'd like to begin with an acknowledgement of the traditional owners of the land on which we are calling from. We are on the lands of the Gadigal and Bidjigal people of the Eora Nation and would like to pay our respects to their elders past and present. As stated, my name is Ahmed Sawan and I'm a supervising solicitor at RACS, and I'm joined by my colleague Mursal Rahimi, RACS's policy and casework solicitor. We thank the committee for the opportunity to provide evidence with respect to the Administrative Review Tribunal Miscellaneous Measures Bill, as it will fundamentally impact the people assisted by RACS. Now, RACS acts for and assists refugees, people seeking asylum, people that are stateless or displaced, who are in the community in immigration detention centres, alternative places of detention, and community detention. Among others, our services include advising and assisting non-citizen applicants with challenging government decisions that fundamentally impact their safety from persecution, liberty, freedom from arbitrary and indefinite detention, and ability to reunite with their families. The applicants RACS supports typically experience structural exclusion and intersecting barriers to accessing justice. Now, these are the applicants whose ability to access merits review at the forthcoming Administrative Review Tribunal is at risk of further erosion with the passage of this bill. The bill seeks to legislate strict requirements for the making of a proper application, including the provision of prescribed documents and the payment of fees within a legislated timeframe. This is combined with the direction that the tribunal does not have the jurisdiction to review applications that are not properly made, and provisions that exclude the tribunal's discretion to not dismiss applications where fees are not paid. RACS is concerned that the bill continues an alarming practice of carving out a distinctive procedural code for merits review, which particularly disadvantages applicants seeking a review of reviewable migration and protection decisions. Now, on a systemic level, RACS is concerned that a desire to process people efficiently at the department level and tribunal level can ultimately lead to a person not being heard before either body without an assessment of claims. Under the Department of Home Affairs' new last in, first out approach to protection visa processing, their application may be assessed on the papers without being invited to attend an interview or to provide further information. Now, while this bill purports to maintain the integrity of the immigration system, where in our experience this was shown by the presence of the Administrative Appeals Tribunal to be able to act as a safeguard for protection visa applicants, to be given the opportunity to have their cases heard, instead it will have the practical effect of invalidating applications for merits review for purely technical or procedural factors. This will most significantly impact the most vulnerable people in the system. A system that bars applicants from accessing merits review instead of engaging with the substance of applications in good faith is not aligned with the principles of integrity. It is one that fails to properly balance efficiency, fairness, and accessibility. Thank you.
Thank you very much. Mr. Mann, the refugee legal, do you have a opening statement you'd like to make before we go to questions?
Yes, we do, and thank you for the opportunity to provide evidence to this important inquiry. We welcome the committee's inquiry into the Administrative Review Tribunal Miscellaneous Measures Bill of 2024. Every year, Refugee Legal assists thousands of people whose rights and lives are directly affected by the core subject matter of this bill, namely access to a fair hearing on review, which is a long-standing and fundamental safeguard under the ordinary protections of Australian law. In this context, many people are seeking access to review on issues which could hardly matter more: protection from persecution, family violence, or the ability to reunite with family. And in our experience, many of these people experience a range of vulnerabilities which impair their ability to access basic rights, including merits review. In our submission, we fundamentally object to the provisions of this bill dealing with access to review and recommend that they be rejected in their entirety. In essence, both proposed as well as existing provisions which constitute barriers to accessing merits review, such as inflexible rules on application fees and time limits, are at fundamental odds with a well-functioning system of merits review, particularly given their impact is harshest on the most vulnerable. Further, they are the very antithesis of the fundamental purposes of merits review as set out in the Tribunal's objective in the Administrative Review Tribunal Act, that it be accessible, fair, just and inexpensive. This is because they would systematically eviscerate the right to review for people who are in most need of accessible means to pursue their legal rights. This gives rise to a central question. Is it seriously contemplated that, for example, women experiencing family violence are to be completely excluded from access to review, from the whole process? And again, is it seriously contemplated that access to the tribunal will only be possible for those who can afford it, and that for those who cannot, the right becomes illusory, and as a consequence, their rights and lives are endangered? Because this would be an inevitable consequence if these provisions are passed. Thank you.
Thank you very much. We'll now go to questions from senators, and if it's helpful, I think senators, you have probably around 10 minutes each for questions. Senator Scarr, will start with you.
Thank you very much, Chair. My first question is, and feel free if you want to take on notice any of these questions and provide a more fulsome written response. But the first question is, to what extent does this bill lead to a deterioration of the existing rights people have to bring applications for administrative review? So to what extent, from the practical perspective of the witnesses here before us, do the concepts in this bill lead to a deterioration in terms of the rights of people under the existing system? So I understand the arguments which are made on a general basis with respect to the position in particular of people who may be in immigration detention, access to resources, financial constraints, etc., and those are all legitimate arguments which have been made. What I'd like to hone in on is how do the witnesses think that the amendments proposed in this bill actually worsen the situation from the position of a potential applicant and from your perspective as advocates for potential applicants. So if I could start with the Asylum Seeker Resource Centre.
Thank you very much, Senator. And to provide context, whilst this bill does worsen conditions for refugees, people seeking asylum and migrants, The previous legislative framework was inadequate, and that was borne out by criticisms that have led to this reform, re-establishing integrity to the merits review system. And the particular parts of this bill that exacerbate access to justice for the groups that our organisations are speaking to that are a particular concern. First is the addition of the requirement that a person provide prescribed documents or information for their application to be properly made and considered. In particular, the purpose of this requirement is unclear. There doesn't appear to be justification for it, and it is undefined.
Okay.
We have a situation.
Sorry, can I just interrupt you there? And I've only got limited time, and I may well tease out some of these issues through you. The Attorney General's Department says in its submission that the change to the reference to prescribed documents and information is intended to provide greater flexibility with respect to the operation of the system, as opposed to being a more onerous obligation. So how would you respond to that characterisation? It's difficult for me to get my head around it because I'm not fully across what documents would need to be lodged under the current system at that initial application process as opposed to at a later date during the course of a hearing. So any practical insight you could give us would be useful.
Absolutely. It's a new requirement. It's one that is fairly unsubstantiated, and the flexibility that is spoken of is of concern, where the consequences include a person losing their right to access merits review at all. Important context is that under the Act already, the decision maker, and in this case the department, is obliged to provide the tribunal with documents. That's subdivision B. That's the decision and any other documents they consider relevant. So from our perspective, we can't see why this additional layer, this additional hurdle would be incorporated. It's something that we know applicants struggle with. We see this all the time, for example, when preparing applications to court, because of the difficulty of understanding additional requirements. At the moment, an application is completed by providing a form. That's appropriate. There are key details that are needed from an applicant to proceed with an application for review. But this requirement is unjustified, reduces accessibility significantly, and does not seem to have any perceptible advantage in terms of efficiency or the other objectives of the tribunal. There's also a risk that those requirements will change and become inappropriate or onerous because the requirements are not defined. It's inefficient, and it's likely to cause questions about substantial compliance in applications. So I would single that new requirement out as a particular development that is disadvantageous and that should not be accepted as part of the framework.
To the extent that the regulations provide for additional, say, prescribed documents or prescribed information, which may make it more difficult for a potential applicant to apply, would that be through disallowable regulations?
In terms of how it would be defined?
Yes.
That might be the case, yes.
Could you take that on notice, and if other witnesses could take that on notice? So from my perspective, whether or not the regulations by which, I mean, you legitimately raised the point about there might be a change in terms of the information that's required, that may be done through regulations or delegated legislation, whether or not the delegated legislation through which that is done is subject to a disallowance process, i.e. parliamentary oversight, is a very relevant consideration from my perspective. So if all of the witnesses could take that on notice, I'd appreciate it. Okay, so can I ask you, what is the current situation if as you understand it, where someone makes a mistake in terms of a form, they think it's been sent, but it hasn't been sent. They think it's been uploaded to the website, it hasn't been uploaded to the website. So back in my old days as a lawyer, there were things called the slip rule, all other sort of discretions, if you like, through the judicial process to accommodate where there's been an administrative cock-up or some sort of mistake has been made, right? So to what extent are those issues accommodated under the current system and from your perspective would not be accommodated under what's proposed under this bill?
Thank you, Senator. Already, requirements are quite strict. The way that it's considered at present is substantial compliance with the requirements for lodgement. That's well established in case law and in supporting legislation. Things like where a form was meant to be sent but weren't are very difficult to overcome. With the way things operate at present, if the error was on the end of the tribunal, there might be a solution, but it's a very complicated area. And if there was a mistake, there is little redress because of how strict the timeframes are. This has been a problem for a very long time. People who have thought they've taken action, but it wasn't received, will find themselves in a situation where their options include going to the High Court at immense cost or seeking the Minister's intervention. There has long been a deep necessity for increased flexibility to accommodate the risk that people lose their right by a slip, as you say, Senator, or by a misunderstanding, particularly given how complex it is to make these cases.
Okay, could I give the other witnesses an opportunity just to address that point in particular, because I'm trying to get my head around how the current system works, the flexibility within the current system, and to what extent what's proposed under the new system would actually exacerbate the challenges which are faced under the existing system. So if I could maybe go to you, Mr. Mann.
Well, in relation to the proposed prescription issue that we're talking about here, I mean, the bottom line is, and I think that the fundamental question that arises is, and this is one, that needs, I think, for the government to provide more detail on, and that is, given that the requirements so far in relation to an application are bare bones, I mean, it's just biodata that's required, how could it be any more beneficial? What actual detail is being contemplated here? I mean, to actually have a provision, it has to be doing some work, it has to have some purpose in mind. And the question that arises here is, what is it? And without further detail, we're all in the dark. But what we can say is that at this point, under the current system, going to your key question at the beginning, under the current regime, it is a very simple bare bones application that doesn't require any substantive information to be provided by the applicant. All it requires is basic details of biodata, effectively. So one must work on the presumption, without further detail, that what the government has in mind here is for an applicant to provide more detail of a substantive nature. That detail at the moment, as has been by other witnesses mentioned, that substantive information is generally provided by the department to the tribunal to the extent it's provided. So that's the first point. The second point is in relation to the slip rule or flexibility. The fundamental problem here is that there is no indication that the ordinary protections of Australian law, which apply almost universally across the system otherwise, right throughout the legal system, once again we have here an aberrant proposal, one where, with no clear justification, what is proposed is a radical deviation from the ordinary protections of Australian law that otherwise apply and that you've referred to when you were a lawyer. And this is one of the core threads of concern throughout this bill is, once again, we see discriminatory provisions which don't ordinarily apply. What's important here is that the ordinary protections of Australian law, where you do have the slip rule, you do have flexibility in relation to requirements in the interest of the administration of justice. What's important there is they are considered to be fundamental safeguards to ensure that someone gets a fair hearing. Why are they to be removed here for people who are seeking migration or seeking asylum protection, women who are seeking protection from family violence? That's the question. And if that is the proposal, which it appears to be, that there will be additional requirements on people largely who are very vulnerable and find it very difficult, if not impossible, in these circumstances to get that information together, remembering getting that information together with non-extendable timelines that they're confronting to apply. So it's a double-barrel problem, with the endpoint being, do they actually even get access to review at all? That question needs to be asked of the government. What is intended here? What are some of the details so that we can actually properly scrutinise this legislation? Without it, we're in the dark on very serious matters that could have life-threatening consequences for people.
Okay, if I could just give an opportunity.
Senator Sky, do you need to share the call? If you have one more question, I can share the call after that. Perhaps if witnesses can assist in their answers being a little bit briefer, and then I'll share the call after that.
Yeah,
Thank you.
Thank you, Chair. I'll just give an opportunity, if I could, to, as my last question, to the Refugee Advice and Casework Service to provide their thoughts on those questions which the other witnesses have responded to. So first, how does, from your perspective, the proposed amendments exacerbate current issues in a negative way against potential applicants? And secondly, to what extent is there flexibility to address, as the previous witness said, these issues that could arise and can be rectified in the interests of justice through the exercise of appropriate discretions, etc., under the existing system, which would be lost under the proposals?
Yes, thank you, Senator. First, I just want to start with agree. I mean, I think, much in agreement with my sector colleagues on this call. But I think one thing that we point out, one thing that we feel that this bill especially does is, and this is something when you mentioned at the start with reference to the Attorney General's statement about providing for greater flexibility, is that with these legislations, it can also provide the architecture of the framework for where the provision of these documents that we've been talking about to change from what they are currently, which has already been explained by my colleagues as being maybe slightly less onerous, to something that all of a sudden becomes a bit more onerous and a bit more substantive, impeding someone's ability to seek that review. So I think maybe one perspective is that it could be more flexible. I think the other perspective is that it could also allow for changes to be implemented that would make it more onerous than it is.
Okay, thank you. Thanks, Chair.
Thanks, Senator Scarr. Senator Shoebridge, you have the call.
Thanks, Chair, and thanks all for your submissions and your attendance today. One of the effects of changing 347 and 348 from the current terms in the Migration Act, which talk about a reviewable decision must be in the approved form, have the prescribed fee, etc., to the new formulation in 347 and 348 that says if an application is not properly made, the ART must not review the decision, and then setting out in 3482 what is required for a decision to be properly made. That's responding to the Miller case, isn't it, in the High Court, which came to a contrary conclusion, albeit under a provision of the Administrative Appeals Tribunal Act, but came to a contrary conclusion only very recently. Mr. Mann, do you want to start?
I might throw to my colleague. It's about the question is about whether this is going to the issue of the Miller case. Yeah.
Well, perhaps I'll put it more simply. The beneficial interpretation that the High Court gave to the AAT provisions in the Miller case could have applied to these provisions in the Migration Act, but for these amendments.
I think that's correct, a correct interpretation of it. Others have spoken about how at the moment the framework is not it's not flexible, but this will make it even more inflexible than it currently is. And with people being required to provide prescribed information. It may well be additional documents they may not have access to, and various matters like that. As Mr. Mann has previously said, we don't know what they're actually intending to prescribe. So the possibility by accepting these amendments, the possibility is that confining appeal rights will occur by prescription.
Can I just add to that one? So there are two options here to cut to the chase in this context, and context is critical as well. And most of the time, all of us appearing today, help. Our agencies help thousands, in fact, tens of thousands of people every year through this process, and most people are experiencing a range of vulnerabilities, which actually immediately or by implication mean that actually access is sometimes impaired to some degree. It's more difficult. And what we're looking at here you've got two choices, I guess, in policy terms. One is to make it to respond to that, which is what would be consistent with the objectives of the Administrative Review Tribunal, to actually be responsive and accessible, and that means to have, if anything, we would argue, not stricter and more onerous requirements, but actually more flexible ones, which also, and I think that the guiding principle ought to be, which is actually, it seems to be the very opposite in this bill, but should be about ensuring that there is the ability to assess an application on the basis of substantial compliance and afford the person an ability to remedy any technical defects. Instead, what we've got is the opposite, it appears.
I'll go to Ms. Saravanamuthu or Ms. Dickinson next, and then to Rax.
Thank you, Senator. We agree. Broadly speaking, in Miller, the court identified a number of, I suppose, difficulties with the purpose of requiring, having more onerous requirements for an applicant to leap that first hurdle of making a valid application. And the court pointed to the fact that the tribunal, once an application has commenced, has numerous powers to obtain information that will correct any deficiencies, any defects in what is before it. And that is the case. That is the case under the reformed tribunal as well. It has ample power to do so. And so the information that might be sought might not be of any assistance to the tribunal. And where we are talking about knocking out a person's opportunity to have any kind of review, it's even more unclear why additional requirements, why we should not heed the observations of the court about the tribunal's powers and about the importance of access, and make a set of inaccessible requirements for people to access their rights. So, Senator, we agree. There is a lot to be learned from that case and from the court's observations in it for the purpose of this inquiry.
So it's pretty disingenuous where the Attorney General's Department says in their submission the bill does not affect the substance of the Miller decision. In fact, quite the contrary. The substance of the Miller decision has obviously informed the drafting of this, and it excludes the beneficial interpretation being applied to applicants that was set out in Miller. That's the effect of it, isn't it? That's the substance of it, to use the AG's terms.
The terms of the bill require that any information or documents that are prescribed must be included, and that does differ from what Miller says. It sets up a different framework from what their honours discussed in that case.
And it prevents the beneficial interpretation that Miller gave under the AAT Act from being applied here if this bill gets through under the Migration Act. It prevents that beneficial interpretation being applied, doesn't it?
Yes.
Yeah.
Yes.
And if you're an applicant, that's the substance of it. You can't get the benefit of the Miller case.
Exactly the case. That is exactly the case. The analysis from the Attorney General's Department appears to be on its face incorrect. But if there's a contrary view from them, I think our question would be, can you help us to understand why that's wrong? Because on its face, it appears to be demonstrably incorrect.
So I might go to Rax then. do you want to add anything to this discussion about what the effect of it will be in light of the, Miller or otherwise?
I think in general, I don't think we have too much to add to what my colleagues have said, in the sense that it seems like the legislation or the sort of the bill that's in front of us does, like you say, go against the decision in Miller in that sense, where it does prescribe documents that need to be provided, whereas obviously the Miller case, as has been pointed out, would have allowed for a bit more flexibility or a bit more sort of powers to be able to obtain information or documentation after an application is made, and not necessarily only at the time of that application.
And the making it, could I go to the provisions about timeliness? What's the reality for someone in immigration detention having to get an application now with a bunch of absolutely mandatory elements in place within 7 days? What's the real world effect of that? And how has it changed?
Yeah, so I think even under the current framework, we see that people in detention struggle incredibly just to get an application in, as it currently is, where all you need is to submit a form and pay a reduced fee, which doesn't even have to happen at the time of application necessarily. So I think the fact that the window to make that appeal remains at 7 days, and you're all of a sudden sort of forcing the provision of certain documents, whatever they may be, for someone who in detention does not have access to, or easy access to, a folder, a file, computers to be able to upload these documents, to then provide them within that incredibly tight time frame, is just, incredibly onerous.
Is there any power, legislative power, given to the tribunal to extend the 7 days, or to permit the late lodgement of a document? Am I missing it? Is it hidden away somewhere in the ART Act or in the Migration Act?
Not hidden anywhere. Don't keep looking because it doesn't exist, is the answer, Senator.
Right.
It doesn't exist. The answer is that the timeline for an application is non-extendable.
So I'll give you a real-world experience. One of my daughters and I were confronted by an unnamed university website that was refusing to accept uploaded documents for a scholarship. And the deadline was midnight one night, and we're desperately trying to lodge the documents, and it just would not accept them. I'm pleased to report it was a system error, not a father-daughter error. And the institution then extended it by 7 days, admitting that there was an error with their system. Change that, and let's say the ART has an error with its system and you can't upload the documents. Does that mean that people's rights just disappear?
The deadlines have always been unextendable. And if there's, and it's a feature of the system across the department and the tribunals, where if something has to be lodged by a particular date and their system doesn't work, well, that's just tough luck.
But
the other consequence is that, just to be really clear on this, that even if in the tribunal there was a view that that's just unfair, for example, because of a system error on their end, there is no power, just to be very clear, there is actually no power of any official to do justice as they might otherwise think. That's the point. There is no source of power under law to actually remedy it.
And these amendments...
No, you've just dropped out. You've just muted there, Rex. We got these amendments and then mute.
These amendments make it beyond doubt that they don't have the power to review, because they don't conform to the validity requirements that are set out in the bill.
Well, indeed, these amendments...
My apologies, Senator Shoebridge, my apologies. I will have to share the call. If you've got one more question you can put to these witnesses. Thank you.
And I might go to Rax or the ASRC. These amendments actually make it harder and more likely that that kind of system error may apply, because 348, the new 348 says that not only must the application be made within 7 days, but the ART can't review the decision unless it's also accompanied by a bunch of uploaded additional documents, which I assume would be uploaded. It actually makes it much harder and more likely for that kind of system error to produce unfairness, doesn't it?
That's right, Senator. These provisions make it even more onerous and impossible for people to access their review rights. And just to add to what our colleagues have shared, the ART does have the power to have flexibility under Section 19 of the ART Act to accept late lodgements, except it's excluded for refugees, people seeking asylum and migrants. Yeah. And that's what we've been, giving evidence about, that these rules are discriminatory. The ART does have the flexibility that's in line with its objectives. However, for the people that we represent on a daily basis, those same rights have been denied. And so that's what we're asking is just for the same rights that other applicants before the tribunal have to also apply to refugees and migrants and people seeking asylum.
Thank you, Senator Shoebridge. I do need to share the call. Of course, if there's questions on notice, I'm sure you'll put those to these witnesses. Senator Ghosh, you have questions, I believe.
Thank you, Chair, and thank you for the witnesses who've appeared here today. Can I just ask to understand the position in relation to prescribed documents and information as distinct from a prescribed form? My understanding of the legislation is that it in effect removes the mandatory requirement for a prescribed form and replaces that with a requirement for prescribed documents or information. Is that the shared understanding?
Our understanding, Senator, is that a form would still be required. These are additional requirements.
Okay. And drawing on some of the points in the submissions, I think it's a point made in slightly different ways in each of your submission. At the moment, the concern is, A, with the addition of the prescribed documents and information, and B, that as matters stand, you're not aware of what that would involve at this stage. Is that right?
That's right.
Yes. Okay, and so the extent of the problem or the harm that's been raised as a concern would depend on the extent of those prescribed documents or additional information.
From our perspective, Senator, any additional requirements are apt to cause injustice and to deprive people of access to their rights. As it stands, it's very hard to lodge, and there are many barriers to doing so. We've spoken about people in detention, we've spoken about people facing particular vulnerabilities, but to give some real-world examples, people who can't contact their families, people who don't have access to any of their normal systems, people experiencing homelessness, people with severe mental health issues, people with language barriers. It's very hard to navigate this system. And with the addition of unclear documents or information that could change at various times and that may be inaccessible, and as we've said, which may serve unclear purpose, there'd be a deterioration in access without question, regardless of what those documents were. Certainly the extent of that would depend on what was ultimately required, but the flexibility and the lack of clarity are of significant concern to us, aside from the initial difficulty with an increase in lack of access.
We would agree with that, and we would just add, we would entirely agree with that, and we would just add that it doesn't depend on what is prescribed, because anything that's prescribed is going to be overly onerous. And just to go to the heart of this, what could be prescribed? Because at the moment, as it stands, if what is anticipated is that relevant documents such as the decision of the department is to be provided, well, that can be provided by the department, okay? So it doesn't need to be the applicant. So that can be done. So what is actually being contemplated here, one would, at a guess, would lead us into different terrain, and that is grounds upon which someone is seeking review. or some other kind of additional evidence, or so either additional arguments or evidence, because otherwise all we've got left, it appears, is documents that are already in the hands of government decision-making, another government decision-making body, which could be readily provided to the tribunal and should be, rather than the applicant, for example, someone detained, having to go to that trouble. So it doesn't, in essence, we would say that there isn't any further information that should be required, and that will only create barriers to accessing the tribunal to seek a fair hearing on review.
So I confess, potentially I'm a little confused, but in terms of whether the information that's going to be requested will be substantively different to what is currently required in the prescribed form. But can I ask this question? Does it? I mean, is one way to address one of the concerns that's been raised, either as a matter of express drafting or as a matter of the proper construction of the statute, that any requirement for prescribed information or documents be contingent on the availability of those to the applicant?
Senator, it is up to cause potentially confusion, introducing additional discretion into that requirement. In our view, that wouldn't solve the problem and would cause likely delays as the tribunal and its staff grapple with assessing whether that is or is not available. Given the bulk of information provided by decision makers under the Act, we still can't see a legitimate purpose for the provision existing at all.
If I may add to that, I think this is all contextualized in the very strict timeframes that we were speaking about just before. So even with any potential further clarity about the documents, I think it still is a matter of then collating, providing, uploading, whatever it may be, those documents within, let's say, a 7-day time frame. And so that's, I think, the point that my colleagues have been making before, which I wholeheartedly share, is that any additional provision of documents and information, vague now, potentially clearer in the future if it may be, remains an onerous task and remains an additional barrier to accessing fair merits review.
Let's add one point to that. Is what's not clear is what's the purpose too. If there was some driving purpose to prescribing additional information, what is it? There's been no information provided by government as to why all of a sudden this appears to be an important additional requirement over and above what we've just been addressing, and that is a range of requirements that exist already which limit the ability of someone to access review. And this just adds to the suite of measures that restrict the very ability to access review. It can only do that. So what is the purpose? It's not clear.
Apparently to improve user experience, according to...
Well, thank you, Senator Shoebridge.
What it's for, to improve user experience.
I think, well, Senator Shoebridge, you were heard in silence as well, so I'd appreciate if you afford that respect to other questioners.
I'll improve your user experience and be quiet.
Oh, well, that's not been my experience to date. Can I take a step back from these additional information requirements and just ask about some of the other requirements that were raised, or some of the other aspects that were raised in the submission? In terms of timeframes, and that was raised in some of the answers, and then also in terms of it was the third, the aspects of fees. Can I understand the submission? My understanding is as it currently stands, this bill doesn't change the timeframes or the fees structure as distinct from earlier legislation or the existing system under the AAT and the Migration Act. I've understood the objections that have been taken in the submissions, but are those essentially objections to the current system or the system as exists in legislation
We have objections to both the current system and what's proposed here. Under the current system, if you apply for review of a migration decision, not a protection decision, but a migration decision, and you're seeking fee reduction on the basis of severe financial hardship, then under the current arrangements, you can pay the reduced fee, and then the tribunal will assess whether or not you're entitled to a fee reduction, and you have a period of weeks to make the additional payment if they assess that you're not eligible for the reduced fee. However, under this proposal, the full fee will be payable upfront within a 28-day period. And for people like women who have fled with their clothes on their back and who don't have access to any funds because their perpetrator has cleaned out the bank accounts or whatever the situation is, it is unfathomable how they'll come up with today $3,500 to seek review of a decision that they've been refused a partner visa because for whatever reason by the department. So they will have no access to review. In some cases that we've dealt with, people have managed to pay the reduced fee by getting funds from charities which should be used for their own survival, not having to pay money to the government.
Okay. Does anyone want to add to that?
We concur with what our colleagues have said, and to add that for people in detention, they have to pay that exorbitant amount of fees within 7 days. They haven't had access to work rights for years. They're often isolated from their families. It's essentially excluding people in detention from accessing migration review. There's no other way that they would be able to raise that amount of funds.
And I just briefly add, in addition to agreeing with both of my colleagues, I think we raised 2 case studies in our submissions where it just shows that the first point of call was our ability to make a review where the fee was not required at the time of application. This was for both the people, one particular person who was in detention at the time and one woman who had been the survivor of domestic violence, where in the first instance, we're able to guarantee that review right and then work through that, producing or providing that reduced fee, and they were able to provide that, obviously with much difficulty, but we're able to provide that at a later date. And I think some of these provisions today would prevent something like that happening in the future.
Thank you. Thanks all, and thank you to the Chair.
Thanks very much, Senator Ghosh, and thank you to all of our witnesses. That's all the time that we have today, and we thank you for your submissions, and if you've taken questions on notice, we'll give you a date to return those to us by. Our next witnesses are in the building, in our committee room, so we will welcome them in a moment if they can come to the table and set up their nameplates. That would be very welcome. I'll just read through the information I have to before we begin. I now welcome representatives from the Attorney General's Department and the Department of Home Affairs. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy, but shall be given reasonable opportunity to refer questions asked to the officer, to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you to state your full name and the capacity in which you appear today? You can start with the Attorney General's Department.
Thank you, Chair. Sarah Samios, First Assistant Secretary, Administrative Review Task Force.
Thanks, Chair. Joanna Virtue, Assistant Secretary, Legislation Branch in the Administrative Review Task Force, Attorney General's Department.
Thank you very much. And the Department of Home Affairs?
Michael Burke, First Assistant Secretary, Immigration Policy at Home Affairs.
Thank you very much. Does either department have an opening statement you'd like to make before we go to questions?
No, Chair.
No, Chair.
Okay, great. We'll kick off with questions then, and I'll hand the call to the Deputy Chair, Senator Scarr.
Thank you, Senator Green. If I can thank the Attorney-General's Department for your helpful table. I actually tracked through the sections myself and then I read your submission and saw you'd done it for me. So I do appreciate that. If I can turn to, where is it? Obviously, we seem to be focused on the Migration Act changes. Attachment B, Administrative Review Tribunal Miscellaneous Measures Bill 2024 requirements for a valid application under the Migration Act. And then you've got a very helpful table. The first column, current state pre-reform, which is the law applying today before 14 October, I think the date is. And then you've got the position under the Consequential and Transitional Act Bill, number 1. Then you've got under this Miscellaneous Measures Bill in column 3, and then you've got your description. I just want to quote this for the Hansard from the description. Before the reform, applicants could only make a valid application by using the prescribed form. CT1, which is the position immediately prior to this bill being adopted, if it is adopted, change these requirements, instead allowing applicants to make an application by providing certain information or documents, rather than needing to complete a form. This provides more flexibility for parties applying to the tribunal, end quote. Now, when I read that, it seems to suggest on the face of it that the intent of the department is to make a more flexible system. But then when I consider it in the context of the provisions which are closing out, from my perspective, at least I've read Miller's case, it seems to definitively close out a situation where, say, you've missed a document or something that was prescribed, then there's absolutely no, it seems to remove any doubt there's any jurisdiction on the part of the Administrative Review Tribunal. That's my interpretation of the effect of the changes. But you seem to be saying that's for the reason of flexibility. But how does, say, going from an obligation to use an approved form under the existing system to an obligation to lodge prescribed information and prescribed documents, and I know it says, well, under the previous bill it said if any, but how does going from an obligation to use an approved form to an obligation to use prescribed information, to lodge prescribed information and prescribed documents provide more flexibility from the perspective of the applicant who's potentially sitting in detention with limited resources and facing the challenges which the advocates in the previous session outlined?
Senator, we're happy to assist on that question. I would say I think several of the witnesses in the last session indicated that a prescribed form was still required. To be very clear, that requirement has been removed. So that was suggested from those witnesses there was additional requirements. These are not additional. The purpose of the change, this is a change, to be clear, from the current position to the position in the ART. It's not a change from the first bill to the current bill.
Understood. Understood.
Okay.
Understood.
So I think it's helpful if you refer to the actual provisions of the migration regulations which set out this information. So currently, to make a valid application, you must use the prescribed form or the approved form. Under the provisions that set out, under the requirements under the migration regulations, it is sufficient to simply hand over your notice of decision. That is sufficient to make an application. You don't need to do anything else. Or if you don't have the notice of decision, and they have the other witnesses have noted it's possible someone doesn't have the notice of decision, it would be sufficient to hand over, for example, a post-it note that said, if you go through the provisions, we can table the material from the regulations which have been made. So you could provide a post-it note that has simply your name, your address and contact details, some kind of description of the decision, and an identifying piece of information, such as, for example, it could be your date of birth, it could be your country of birth, country of citizenship, or statelessness, if that's the case, or a passport number. Any one of those would be sufficient, together with your name, your contact details and some sense of, it's a student visa issue, for example, would be sufficient. So genuinely, it means that people aren't falling foul of the requirement by not using the required form. There is still a form you can use, and if you use that form, you would comfortably meet the requirements under the regulations, but it's no longer the case that it has to be on that form.
Nobody's complained about the form.
Well, no, actually, Senator, I think we had quite a lot of complaints through the consultation process we undertook in the previous bill. As I said, this is not a change in this bill. The consultation process we had in the previous bill was that the ability to access the form and to fill in the form was a challenge for some people, and that the most flexible approach, for example, saying, I want to appeal, here's my notice of decision, would be would give a broader range of opportunities, and that's in fact what the regulations provide for.
So really okay, I understand now. And I think it would be helpful for you perhaps to take my question on notice and give a formal written response in that regard and provide the detail around the regulations. So really, it's, as I understand what you're saying, it's really what's being proposed is you can initiate the application through completing the approved form.
Absolutely.
Or providing the prescribed information or documents through, sorry, let me finish, or providing the prescribed information or documents through some other means of communication.
That's right.
Written communication. Is that correct? That's the intention?
So, Senator, if I
Do you understand what I mean, Mr Burke?
Yeah, so I think, so just to clarify, and I think this is really important, this bill, Miscellaneous Measures Bill, is not changing.
No, I understand that.
Okay.
I understand that, Mr Burke.
And then your question around, well, hang on, you're saying it provides more flexibility. How is that the case? That goes directly to the regs, which provide a wider range of options for the applicant to be able to demonstrate that they have, in fact, met the requirements of the application. As Ms Samios has mentioned, feedback through the Attorney General's Department's process did highlight challenges experienced in using the form. This provides greater flexibility for the applicant because there is a greater range of prescribed information or documents that can be used by the applicant to make that. And again, this regulation has been made. It is in effect. It is visible to the Senate.
Why is there this disconnect then? I mean, you were here listening to the stakeholders who, just for the Hansard record, for the stakeholders who are dealing with thousands of cases are all reading this and they understand, Mr Burke, the legislative chain, I think, but they're interpreting this as putting more onerous or potentially putting more onerous obligations on applicants, whereas the intent of the department is that it is intended to make it easier, if I can put it that way, for an applicant to comply. Why is there this disconnect? Was there consultation with the stakeholders before this bill was prepared?
Well, in relation to the consultation, that would have been when this requirement was made. So before there was copious consultation, a range of issues. I got the sense from submissions that people who were making those submissions hadn't reviewed maybe the regulations that set out the requirements.
But with respect, with respect, Ms Samios, they're dealing with the regulations every day, aren't they?
Well,
when they're representing.
Yeah, Senator, I don't think it's for us to comment on submissions made by others.
No, but it is for you to comment on the reality that there appears to be. Well, it raises in my mind the effectiveness of the consultation between the department and key stakeholders with respect to the formulation of these provisions, because on my reading of the evidence through the submissions, there's a legitimate concern that this is going to make it harder for potential applicants, as opposed to easier for potential applicants to comply, and that causes me some concern.
So, as I said, I don't think it's for us to comment on submissions made by others, but as a general comment, it does from time to time appear through submissions made to legislation committees that people focus on the amendment without referencing the act that is being amended. I think in this case, and when you read some of the submissions, it's not clear that there's a great understanding that this is not changing any requirements, it's not changing any timeframes, it's not changing any requirements. As Ms Samuels has outlined, they happened in an earlier bill where there was extensive consultation undertaken, and Ms Samuels would be in a better position to outline that. But I would note that did happen earlier in the year, so some time has elapsed between that process of consultation where the changes were actually made and the discussion we're having today on the Miscellaneous Measures Bill, which doesn't change any of those provisions. It rather just seeks to clarify when an application has been validly made.
Okay. If there are amendments made to the existing regulation, which you've referred to, which on the basis of your testimony, which I accept, that you could fill out a post-it note with the relevant information, and that would meet the prescribed requirements under the prescribed regulation. Presumably, if that regulation were amended to provide for example, more onerous obligations, would that be through a disallowable regulation?
Correct.
That's correct.
Yeah.
That is correct.
Okay.
And it might be worth noting, Senator, that that's a distinction from the current situation with the form, where if there was a change to the form to make it more onerous, there's no disallowance mechanism.
So in that sense, we've actually
It's more
greater
capable of
scrutiny
scrutiny. Yeah.
of what is required.
Well, that's an important point. Could I ask you to take on notice and just provide the legislative support for that proposition? Because I think that is an important point, that, as I understand what you're saying, under the current or under the AAT scheme in effect until 14 October, a government, the executive, could amend the approved form, presumably put in obligations that the approved form contains certain information, etc., and therefore make it more onerous. And if the executive did that, that is not subject to disallowance by the Parliament. Is that correct?
That's my understanding. We'll put some material on notice for you, Senator.
Okay, if you could, I'd appreciate that. Okay, all right. Well, look, that's actually been very useful from my perspective. When did you make this? When did the department? How did the department become aware that they needed to make the amendments to this section that are being proposed through this bill? So obviously, you would have gone through a process as part of the drafting of the ART bill and the consequential and transitional amendments associated with that bill that were introduced at the same time. You've then made a decision that we need to clarify this point. What was the catalyst? What was the trigger for coming to that view from a departmental perspective? And was it the Attorney General's Department? Was it the Department of Home Affairs? How did that all come about?
Senator, we've been working closely in Attorney Generals with the Department of Home Affairs throughout this project. So I would say it was probably in the course of discussions generally, so combined sort of identification of the issue. I think it's fair to say when you work through how you're going to implement a legislative framework, sometimes that flushes out things that could be clearer within the legislation itself. So it was partly in the course of operationalising the legislation and how the AAT translates the requirements of the legislation into their operation, their systems, etc. But also looking closely at the Miller decision. And I would say that the bill doesn't engage with the substance of the Miller decision in the sense that, as was identified in previous sessions, the Miller decision was considering requirements under the AAT Act and not these Migration Act requirements. The Miller decision was about the requirement to provide a statement of reasons with the application for review.
Yeah, sorry to cut you off. I've read the Miller decision. Yeah. I read it over lunch today, exciting lunchtime. But can I challenge you on that, or put the alternative point of view? As I interpreted Miller was saying, even if a section of an Act uses what they refer to as an imperative language, you must do X in order to comply. That doesn't necessarily mean that if you don't do that thing, you lose your rights, okay? Because it may be, I think the word they use in the decision, an exhortation to do something. Whereas the drafting which you've inserted in this bill actually says, well, in the first case you must do these things, but if you don't do these things, the ART must not consider the application. Doesn't have jurisdiction to consider the application. And from my perspective, to be frank, reading the Miller decision on an objective basis, you're actually closing out the issue under Miller, which was that the legislation in the context of the AAT and how it was set up was interpreted as not closing out the rights, the jurisdiction of the AAT in a situation where you hadn't met one of those imperative requirements. However, if the legislation had that additional subsection which you've added here, that the ART must not consider something, you're effectively closing out what I'll refer to as the Miller loophole. That's my interpretation of the drafting. Am I incorrect?
Well, to a degree.
To a degree. Incorrect or correct?
To a degree, I don't know. Actually, what I will say is we don't know. Because the Miller decision, what it says is that must doesn't always mean must. Sometimes it means must, sometimes it doesn't mean must. And the actual requirement they were considering in that decision was the statement of reasons, which we all agree, and the court agreed, is not an essential component of one of these applications. That's why it's no longer a requirement under the ART Act. So whether these Migration Act components would be considered to be musts or Miller loophole type musts, we don't know. But what we do know is that it introduces uncertainty in relation to that question, and it doesn't help anyone not to know whether an application requirement is mandatory or not mandatory. It's better if we're all clear.
Okay, and I think what you're saying, Ms Virtue, comes back to Ms Samios's point that what we're dealing with here is a higher level of information under the existing regulations, which simply identifies who the applicant is and what the decision is, as opposed to trying to interpret something which puts a more onerous obligation under an applicant. Is that a fair comment, Ms Samios? Or Ms Virtue?
Yes, that's right. So the approach is to make it easy to meet the information requirements, but it is essential, because otherwise, if the tribunal doesn't know who the applicant is or how to contact them, then they have this application, and what can they do with it?
Okay, I understand.
So I mean, and I think that was the point I was going to make earlier, Senator, but I think we got onto other issues. But the requirements that are in the regulations in relation to these documentary issues are specifically intended to make sure the tribunal has the bare minimum information it needs to identify the person infected and the type of matter under review.
And of course, that's materially relevant when we're talking about people who, after having lodged an application, may then have access to a changed visa status. So we need to know that someone has made an application, and we need to know that that application is valid. If we have a kind of amorphous, maybe they have, maybe they haven't, it's very hard for the Immigration Department to know whether they are now entitled to that bridging visa or not.
No, I understand. Okay, that's been very useful. Thank you very much.
Thanks, Senator Scott. I'm just going to share the call to Senator Shoebridge. I'm not, Ms Samios and Ms Virtue, I'm really sorry. When we're on video conference, it's a little hard if we have if people are talking at the same time, and I know you're not doing that intentionally, and I'm confident that Senator Shoebridge won't speak over you, but if people in the room could just be aware of that. It's a little hard to know who's speaking at the same time because the camera doesn't go as quickly as your voices do. So if you can pace it a little bit for us, we'd appreciate that. Senator Shoebridge, you have the call.
Thanks, Chair. The amendment proposed to 347 of the Migration Act provides the applicant must be made and any prescribed information or prescribed documents must be provided. And then you've given what the current list of prescribed information or documents is with this, this reg. Prior to this amendment, or prior to the bill going through. What's the current prescribed information that must be provided?
So currently it's a prescribed form, not prescribed information.
So there's no current prescribed information.
The form requires information to be included, but it's in the form as opposed to as a separate requirement.
You say prescribed form.
Approved.
Do you mean the reference in the current 3471A?
The approved form, yes.
So,
Some of which
right.
require attachments, Senator.
All right, so there's an approved form. What are the current prescribed documents? So there's no current prescribed information. So what are the current prescribed documents?
I think, Senator, we'd have to take that on. So it's not prescribed documents. There are documents required in the form, so it's encompassed in the approved form.
All right. So currently the only prescription, if we can use that form, is, sorry, that's confusing language. Currently the only requirement is an approved form. You've got to put the approved form in.
In relation to the kind of information and documents piece, it's the approved form. Yes, Senator.
And it's going from an approved form to prescribed information and prescribed documents.
That's right.
All right. And currently under, if the rationale in Miller is applied to these provisions of the Migration Act, that that must doesn't mean must, and if you provide the substance of the information and not the form itself, you can still have a valid application under the current law. The effect of 3482 is to shut that door entirely, isn't it? 3482 says unless you provide the prescribed information, there is no valid application. That's what 342 says. Unless you provide all the prescribed information and the prescribed documents, there is no valid application. That's what 348 says. The amendment.
So, Senator, it's correct that there's now a different requirement, but the type of material required is very straightforward, as I've explained.
Well, there's a different requirement, which is now you must provide prescribed information and prescribed documents, so that changes. And secondly, if you don't provide the prescribed information or prescribed documents, if you don't provide even a small part of it, the effect of 3482 is that the application's not properly made and there's no application. That's the effect of 3482, isn't it?
That's correct, but as Ms Samios mentioned earlier, in practice, the tribunal will have a form, and if you fill in that form, you'll have a valid application.
So
if you can't fill in the form because you don't have access to it or there's 9 pages and you can't understand it, you can provide the notice of decision. If you can't provide the notice of decision, you can provide some basic contact details and a description of the decision that you're seeking to review.
But under the current law, if you fill in the form, there's no question you have an application, so that doesn't change.
Yes, Senator, but you may fill in the wrong form, you may not have access to the form, you may not fill in the form.
And then you might be able to rely on Miller to say, I may not have provided the right form, but I provided the substance of the information and there's a valid application. Mr Burke, that's right?
Yes, certainly the purpose of this bill is to create clarity, to avoid that ambiguity of maybe you have made an application, maybe you haven't. That is the express purpose of this bill, Senator.
Yeah, you say
Senator,
avoid ambiguity. Yes, it does avoid ambiguity. It avoids ambiguity by ruling out unambiguously a whole lot of applications, by putting a harsh, inflexible, non-discretionary rule in place that is going to rule out a whole series of applications. That's the clarity you're providing, isn't it, Mr Burke?
I would not characterise it in the way that you're characterising it, Senator.
How am I wrong?
I don't think that it could be characterised as, well, I didn't have the full list of adjectives. It's not inflexible. As we discussed with Senator Scarr, it provides options for the applicant, depending on, as Ms Virtue has mentioned, depending on the documents they may have to hand. So rather than having to comply with the approved form, it provides options. They are, as has been discussed, they rank from the most simple of just a copy of the notification that you've received. It's really just about, and Ms Samuels alluded to this, it's really just about ensuring there is enough information that the tribunal can actually register who the individual is and what's the decision that they are seeking to have reviewed. So I don't think that we at all would consider that is harsh. It's added flexibility. It's essentially lowered the standard of information required, and it's improved transparency. It's made it much more easily accessible to people. It's on the face of it, it's law. It's not in a form. So yes, very much it is the case that the intent was to make clear, but also to simplify and standardise.
You see, Mr Burke, your answer has confined itself entirely to the changes in 347, and I understand why you're doing that. But I'll draw you to the change that's proposed in 348.
Sorry, I thought your question was 347, sorry.
348 says, subsection 2, if such an application is not properly made, the ART must not review the decision. That's the harshness. That's the inflexibility. Tell me how I'm wrong in describing that as inflexible.
So again, as was discussed with Senator Scarr, it's really important, particularly in the context of a migration system, that there is clarity around when an application has been made. An open-ended or ambiguous kind of situation does not really help anyone, and certainly it doesn't help the applicant, who may or may not be entitled to a visa, well, who would be entitled to a visa if they've made the application, but no one really knows if they've made that application. So I think to characterise that as being harsh certainly would not be how we would consider that. It is about providing the greatest opportunity to applicants to seek their review rights, whilst also allowing the migration system to function in a way that balances access with integrity concerns.
To suggest, Mr Burke, that making an inflexible rule that the tribunal has no discretion to in any way ameliorate, and changing the law so that applications are made unambiguously invalid, to suggest that benefits applicants really does push the English language to new and unhelpful points. It does not benefit applicants, does it, to have it in black and white that the application is invalid and that they have no valid application before the AAT. That does not help applicants, does it?
I think for an applicant to be able to see written in black and white exactly what makes an application valid is very helpful to an applicant, Senator.
To see written in black and white that your application has been rejected because you didn't pick up one element of the prescribed information that you discern from going from section 347(2) of the Migration Act to the newly made regulation 4.12A of the regulations, and to realise you missed one element in that and therefore your application has been ruled invalid, is hardly clarity and it's hardly beneficial legislation. You go for a wander through the Act, you go through a wander through the regs, you miss one element in this quite complex set of regs, and you're ruled out permanently. How is that beneficial?
Senator, I think it's just useful to compare the current position, the position under the Consequential and Transitional Bill, and the proposed position under this bill. In each instance, both, there's the fee to documents change, which we've discussed, so I won't rehash it. But in the current position, it's the form to documents. The form currently, the documents and/or information in the future are required for a valid application. That is the current position. It's the position under Consequential and Transitional 1, and it's the future position. The same is the case in relation to the requirement to meet the time frame, and the same is the case in relation to the requirement to pay the fee in the instance of migration, not protection matters.
Well, can you point to me the current law in 347 and 348 that this bill is seeking to amend says the form must be provided within a certain time frame. Miller has said, well, when you've got must in relation to this type of application, you're looking at, and it's about jurisdiction, you're not going to read must to oust the jurisdiction of the tribunal if it's been complied with in substance. And they've said that in comparable provisions in the AAT Act, when the law says X must be provided, that it's not providing that doesn't mean you don't have a valid application. And you have, in these amendments, absolutely shut the door on that, haven't you, with 3482? You've read Miller, you've taken on board Miller, and you've said we're not going to have that kind of beneficial interpretation here.
Senator, I wouldn't characterise Miller exactly as you just have. I think that Miller is not so much concerned with the consequence of not meeting a requirement as it is to what the requirements are. So the decision, the effect of the decision is that the statement of reasons is not an essential requirement of an application, not that an invalid application does not invoke the jurisdiction of the tribunal, if that makes sense. So it's about what the requirement is rather than the consequence. Mm-hmm. This bill does not change the consequence of not making a valid application under the Migration Act. And if, as Ms Samuel said, if you refer to 348 of the Migration Act as amended in Consequential Act 1, there is a note there that says the ART has no jurisdiction to review a decision if the application for review is not properly made. Section 348 refers to the requirements under 347 and 347A, which are the exact same requirements under this bill in relation to standing, the payment of the fee, the information and documents to be provided, which we've talked about, and the time frame.
You're referencing a note, and you might help with the committee by telling us what the legal effect of a note is compared to the legislative prescriptions you're putting in this amending bill. What's the legal effect of a note?
Well, I would hesitate to give legal advice to the committee,
you've taken us to the note.
But I will say, as my understanding of the legislation is that the note reflects the position under the current law, which includes jurisprudence and the legislation. So when we talk about what will help an applicant, it's probably not understanding that jurisprudence that allows the tribunal to dismiss an application that's not been properly made. It's probably more helpful for that to be clear to an applicant on the face of it.
What's the effect of a note? Is it law? Does it change the law? You've taken us to the note and you've said the note is the equivalent of this amendment you're putting in 3482. That's not true, is it?
Sorry, Senator.
Don't let him draw you out.
It's not
Sorry,
true.
Senator.
It's
I'm
not
not
true.
saying the note is the equivalent. I'm saying the note reflects the current provision.
Knows how legislation works.
Well, but you have said this makes no changes because it's moved it from a note in the amending to an actual substantive law here. You've said that makes no changes. And I'm challenging
Senator,
you on that and saying that's not my understanding. And I'm clarifying if that is your understanding.
It is not, Senator. That wasn't my evidence.
Well, then it does make a substantive change, doesn't it? Because it pulls something out of a note and it makes it law. And you're from the AG's department, I'm a mere senator. That does change the law, doesn't it?
Self-deprecation won't
Senator,
get you anywhere.
There's a reason why the note is there, and it's not because it isn't true.
But it doesn't have legal effect, does it? It doesn't change the law, whereas this changes the law. That's the difference, isn't it? That's the difference, Ms Virtue.
I have nothing to add.
Senator,
Okay.
we don't think it changes the law in effect in terms of what applies.
Although I thought you said you drafted this in light of Miller. I thought that was your evidence,
The Commonwealth's
Ms Virtue.
position is the same throughout, but we are seeking to make the provision as clear as possible given its import.
No, but I come back to the point. I thought you said you drafted this in light of Miller. Now, was that your evidence, Ms Virtue, or did I mishear?
It's informed by consideration of a decision where must sometimes means must and sometimes it means Miller loophole.
Yeah. And you have said in this case, no Miller loophole. You don't have it, the application the ART must not review or continue a review. You've said that. No Miller loophole.
The Commonwealth's position is that these things are essential to a valid application, Senator.
And you say that's clarity, but did you hear every one of the witnesses before this in the previous panel where they said, well, it might be clearer, but it's harmful to their client base and it will exclude applications in circumstances where it's unfair to exclude applications. Did you hear that evidence?
I think what's really important to bear in mind is that we're not moving from a set of requirements that are one thing and then a set of requirements that are something quite different. It's the same set of requirements in both instances. We are moving from something that is potentially a little bit unclear to something that is more clear. And so the conversation needs to be about the benefit of, I think, clarity versus whether or not it's helpful to people to not know. Because there may or may not be a Miller loophole, but that's not going to help an applicant know how to make a valid application. It's not going to help the tribunal to know how to deal with an application when they receive it. The only way you'll ever get that certainty is to go through the courts, and that's not helpful to anyone.
So it's clarity of drafting.
Senator Shoebridge, I need to share the call, so this will have to be your last question.
In the event that an application doesn't meet the prescription in 348 and the applicant is told that they must not, that the ART will not review or continue a review, have you done any modelling about what that's likely to mean in terms of federal court applications?
Senator, in substance, we think no change because these requirements are all already implemented in this way by the tribunal.
Since when do you say it's been implemented in that way by the tribunal?
Senator, I wouldn't want to go back and say exactly because I think, there has been an extended period where there might have been adjustments, but it's currently the case that if someone's application does not meet the requirements of the timeliness of application, the fee being paid in the terms required, or the form, that it's not a valid application. That's the current position, and that's the proposed future position.
And is it how long is it your understanding that that's been
I don't know when it was not the case, Senator. Which is not to say that there may not have been changes, but it has been the case as long as I have been aware of the issues.
So to the extent people may have been going down the Miller pathway before, you say that won't change. Although, of course, it may change because the Miller pathway is shut down with this. So have you had a look at...
This is the question around clarity. We think it's really important the provisions are clear, but there is no change in practice other than the matters we've specifically outlined.
You see...
Senator Shoebridge, I think that's a couple of follow-ups from your part. This is going to have to be your last question, right, and then I'll share the call.
See, one other way of providing clarity would be a savings provision that says if Section 347 as amended has been substantively complied with, then you have a valid application. It wouldn't be as prescriptive. Say, for example, if someone made a slight error in not including their middle name, they could still have a valid application. But as I read it, under your prescriptive changes, if somebody doesn't include their middle name, they're out, aren't they? Under 412A3A. If you don't include your full name, if you drop off your middle name, you get 348'd, don't you?
So first of all, you're not. If I could just clarify that, you're not looking at 4.12A3 unless you haven't either filled in the form provided by the tribunal or provided the notice of decision. So this will be the minority of people. But I don't think it is the case that you would be 348'd, as you put it, for not including your middle name, unless that was essential to the tribunal being able to contact you and progress your application. But we can confirm that on notice.
We'll take that. We're happy to take that on notice and confirm that position, Senator.
But I think...
Thanks, Senator.
Chair.
I do need to chair the call. If you have something to add to that answer, then I'll do that.
I do. Thank you, Chair. I'm not sure that adding a subjective term enhances clarity.
Well, if clarity
Thanks,
is seen, applications
Senator
rejected,
Shoebridge.
applicants would like that.
Thank you, Senator Shoebridge. Senator Ghosh, you have the call.
Thank you, Chair. Ms Virtue, you used the expression earlier that essentially it's the same set of requirements under this provision as currently exist. Are you able to outline what the information and documents that have been prescribed are?
Senator, in terms of for the ART or for the AAT?
For the ART.
Yeah, Senator, I think we've got, it's a slightly lengthy provision, but we've already offered to table the relevant sections of the migration regulation amendments that will come into force.
Okay. Are you able to elaborate on, or perhaps just clarify, these are essentially, or is it the case that these are the same information and documents that are required to be provided in the prescribed form as currently exists or has previously existed?
I don't think that is the case, Senator, and there are a number of different approved forms, so the answer may vary depending on the type of decision being applied for. I would maybe note that one of the reasons the previous legislation the previous Consequential Act 1 moves away from the prescribed form is that Migration and Refugee Division is the only jurisdiction in which a prescribed or an approved form is needed. In other jurisdictions, it is more about what information is needed with your application. So it was actually an attempt to make it easier and more flexible for applicants. Because those forms will range from, I think, currently 9 pages to 20 pages. Some of them require attachments. I think, in general, the notice of decision is requested if people have it, but we know there are some instances where people may not have access to the notice of decision. For example, if they are experiencing exploitation or violence and the notice of decision is with the person they are attempting to escape, we wanted to provide another way through.
Do these changes make it more or less likely that an applicant will be denied their right to appeal because of a technical issue with their application?
I have to think it's less likely, Senator, because as we've said, they can fill in the form on the Tribunal's website as they do currently, and that would result in a valid application having been made. But there are other means to be able to make a valid application.
And yes, I think that's right. And the other requirements are effectively unchanged.
There was some evidence before from earlier witnesses, and it was a proposition put by Senator Shoebridge as well around the so-called Miller pathway or Miller loophole. What's the effect in terms of applicants of these changes in relation to that so-called Miller loophole?
I think the difficulty, Senator, is it's difficult to say with any clarity, because the Miller decision concerns an application requirement under the AAT Act, which no longer will apply from the time these legislative reforms come in. It doesn't directly engage with the provisions being amended with this bill.
And I'd add, and the particular requirement in the AAT Act that the Miller decision concerned has been removed entirely in the ART Act.
If, as I understand it, at least part of the reasoning in Miller is a distinction between form and substance in terms of an application, does the requirement to provide information and documents rather than an application form permit a greater focus on substance? Put another way, does it remove the need for the Miller loophole?
Senator, I don't want to engage on the later half of your question because I think that's probably a legal question we can't give advice on. But in terms of the first part of your question, certainly the intention is that the substance rather than the form is the most important thing.
May I understand one of the answers that was given earlier, which is that I think it was by reference to, as matters currently stand, if there isn't a submission of an approved form, the payment of fees and the meeting of relevant deadlines under the Act, then the AAT wouldn't consider that application. Is that right?
The AAT would not have jurisdiction, that's correct.
And does that change under the new legislation, including this bill?
Other than that minor change, well, the change we've rehashed in detail about form versus documents, no.
Now, I think, Mr Burke, you gave some evidence earlier about the importance of clarity on whether an application for review has been properly made. Are you able to elaborate on that answer and specifically if there are any implications for people on, for instance, temporary visas?
Senator, yes, to the extent that a valid application for review does then trigger access to bridging visa, and so that allows a person to remain in Australia lawfully while the decision is being reviewed. I guess the point that I was making there is that it's linked to the application for review. So if we don't know whether an application for review has been made, and recognising that when someone is refused a visa, if they're onshore, they're refused a visa, there will be a brief period where they will remain lawful, but at some point they're going to become unlawful. That, by definition, they've been refused a visa. And so it's really important for us. I'm sure it's very important for the ART to know when an application has been validly made, but it's very important for us as well, so that we know to then put in place that visa to allow the individual to remain lawful in the community while the AAT, or in future the ART, reviews that decision.
Now, I understand from the overall scope of this bill that while the focus today has been on its effect on migration, that it has a broader import, or rather it gives effect to a number of changes in other areas of administrative law. Are you able to give us an overview of what the bill does in spaces that are not migration or outside the migration space?
Yes, Senator, happy to do so. I'll try and keep it fairly brief. It is lengthy and it does touch on many pieces of legislation. So the bill makes technical amendments to 52 acts, which is across 14 portfolios. And a lot of those changes are to update references to the AAT in acts that have recently passed the Parliament or are yet to pass the Parliament, and in some cases also to standardise the drafting and clarify the operation of laws. So 14 acts are amended to update terminology and references, 30 to standardise provisions relating to ART Act procedure across the statute book, and 8 acts are amended to correct and clarify drafting. Most of the amendments are minor and technical to support efficient conduct of tribunal review, to update references to ensure the legislation operates as intended. If I were to draw out some specific matters that are particularly substantive, one change is to pause the timeframe for appeal from a decision of the ART to the Federal Court over the Christmas New Year period, so to extend that review time. Another is to ensure that powers and functions in the intelligence and security jurisdictional area may only be exercised by ART members who are determining the matter. Another is to ensure that where a proceeding is before the Guidance and Appeals Panel, the original decision maker may not alter the decision under review except in accordance with the requirements under the ART Act. And a final one is to remove time limits for seeking internal and tribunal review for Aboriginal Study Grant Scheme and Assistance for Isolated Children debt decisions, to align those with other social security decisions and avoid disadvantage to those applicants. I could spend more time, Senator, but I think that's probably a good overview.
Thank you. One of the observations insightful as ever that my colleague Senator Scarr made earlier was that there appears to be a disconnect between the stated objectives of the legislation and the reaction or the concern that it has provoked. In terms of the overall objectives of this legislation, are you able to speak to what was being tried to be achieved in the migration space and address some of the concerns that were raised earlier by the witnesses in the previous panel around, for instance, the imposition of fees, the timing of in-detention application, and then, of course, the information requirements?
Sorry, Senator, we're just seeking to clarify, do you mean in this
bill?
bill?
Step one,
in
sorry,
this bill
that was
specifically, or in the ART reform more broadly? Because those two have...
I'm specifically going back to the migration space, so I appreciate my earlier question was more general, but I guess what are the actual objectives of this bill in the migration space?
I think we've covered it pretty substantively. It's to ensure clarity in the operation of key provisions.
And I think as we've discussed previously, Senator, to be very, very clear about this, this bill doesn't change kind of what's required. It doesn't change the time frames. That was all set in the earlier consequentials bill. This bill is just around providing that enhanced clarity around when an application can be deemed valid. So this bill itself, this bill doesn't change the timeframes. This bill doesn't change the fees. This bill doesn't change the need for the prescribed information or documents. Those already exist under a previous, should call it an act, I suppose, the earlier act for the consequentials and transitionals. This bill is, in terms of the migration space, this bill is just about providing greater certainty and clarity of when a valid application has been made.
Thank you. And thank you, Chair. Those are the questions I've got.
Thanks very much. Senator Polley, are you still on the line? I'm not sure if you had any questions. It's a little hard for me to see from here who's with us. So I think that might be all the questions we have for the department, and I want to thank you for your evidence today and for your submissions. If there's any questions that you took on notice, we'll give you a date to return those to us by. I imagine it being a very short turnaround time. Just to flag that with you. Thanks for taking the time to give evidence.
Thank you, Chair.
You all did very well.
I now welcome representatives. Thanks, Senators. Sorry, we've got half an hour to go. I now welcome representatives from the Administrative Appeals Tribunal. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department of Commonwealth or State shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of an officer to superior officers or to a minister. Sorry, this might be... Yeah, thanks. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear today, Mr. Hawkins?
It's Michael Hawkins, Registrar of the Administrative Appeals Tribunal.
And we're also joined by Ms. Haddad.
Sabeth Haddad, Chief Lawyer, Administrative Appeals Tribunal.
Okay, brilliant. Thank you both for joining us today. Do you have a brief opening statement you'd like to make before we go to questions?
Only very brief, Chair.
Thank you, Mr. Hawkins.
Yes, sorry, Michael Hawkins. Only a very brief statement, Chair, and that is if there are perceived uncertainties in the legislation, then the Tribunal welcomes creating certainty and clarity.
Okay, thank you. That's a very brief statement. We appreciate it. Senator Scarr, over to you.
I was going to say that sounds like a haiku, one of those short Japanese poems. So I appreciate that opening statement. It was very zen Registrar, and good to see you in that mindset. It's been a very tumultuous time for you and your team. So once again, I convey my appreciation for all the work they're doing.
Senator, to that end, I might add that the Chief Lawyer and I apologise for not being in the room with you today. We certainly mean no disrespect to the senators, but with 1 week and 2 days until we commence the new tribunal, we do, as you say, have a few things on. Okay. Registrar, I'm considering these provisions in the context of the caseload of the AAT. I note that, and I've got copies if people would like me to formally table them, but just from your website, Registrar, I note that there's an AAT caseload report from 1 July 2023 to 31 May 2024, and then there's an AAT caseload report from 1 July 2024 to 31 August 2024. And that demonstrates or indicates to me, and I want to give you an opportunity to provide your perspective, the migration and refugee workload or cases on hand at period end, as at 31 May 2024, was 59,543, and the cases on hand at period end for migration and refugee section as at 31 August 2024 was 68,970. So it in fact had increased by 9,000, and when I look at the other statistics in these two caseload reports, they also indicate as at 31 May 2024, the proportion of applications finalised within 12 months of lodgement was 29%. As at 31 August 2024, the situation had deteriorated to 23%. And perhaps most concerningly, the median time to finalise in weeks had deteriorated from 131 weeks as at 31 May 2024 to 199 weeks as at 31 August 2024. So in a period of only 3 months, the median time to finalise cases had deteriorated by over 1 year, 58 weeks, as I calculate it, over only 3 months. Can I ask you, Registrar, how you explain that what I interpret as a substantial deterioration in terms of the completion of cases, at least in the migration and refugee stream of the AAT in only 3 months? Senator, without having that report at my fingertips, I think there's two separate issues there. The first one is the growth in our cases on hand in migration and refugee, and that can be attributable to a very sharp increase in student visa applications during May and June alone, which has continued through till August. There's also been an accompanying increase in applications in the protection visa field as well. In relation to the other issue being the perceived blowout in finalisation time, we received, as you might recall, a funding boost last year wherein we appointed new members for a period of 2 years to deal with the protection caseload. And they have been dealing with the most aged of cases, being 6 and 7 years. So they have been finalising those, and during that period that you refer to, that 3-month period, they would have finalised 3,000 matters, all in that 7 and 6 year category, which blows out the average because a matter is determined in its hearing time from application to finalisation.
Okay. So I think so what you're saying in that regard is, to the extent the additional resources assisted you to finalise matters which had been outstanding for perhaps 5 or 6 years, that actually has an impact on the medium time to finalise, because it's only once cases are finalised that the data for the period of time to finalise those cases enters into that metric, correct?
Right, correct.
Which in my mind, raises an issue about the metric, because I'm looking at it and it indicates, as I expressed it, a deterioration, whereas from your perspective, Registrar, it perhaps hides the fact that those cases, that a number of cases that have been outstanding for 6-7 years have now been resolved. Is that correct?
Correct. Senator, if you turn to another page on that report, if it's the one I believe you have, you can see the aged, that there's a graphic on the age of cases, and you'll see that our aged caseload has actually diminished from what I recall was about 33% being 3 years and above.
Okay, I haven't got that in front of me, but I remember when I looked on the website, you had that graphic. So I've got the tables I'm looking at from the website. So, but I didn't print out the reference, but I now have a better understanding with respect to the issue. Okay, so in terms of the increase in applications themselves across May, June and August, are they applications I think you talked about two categories. The first was applications in relation to student visas. So those are applications to appeal rejections of student visa applications, is that correct?
Correct.
Do you actually have a breakdown of those numbers in terms of AAT lodgements that you can take on notice, perhaps for the last 12 months on a month-to-month basis?
I can certainly take that on notice for you, Senator.
Okay. And the second category of cases was the protection visa category, is that correct?
Yes, and I can do the same for that too.
Okay, thank you. To what extent when an application is made to the AAT for review, and a lot of the evidence we've been taking today and the testimony we've been hearing is around the requirements that need to be met in order for jurisdiction to be established in the AAT, does the AAT have any processes or protocols in terms of engaging with persons who might be in detention, who might be facing culturally and linguistically, who might be of a cultural and linguistically diverse background, who might have limited education? How does the AAT manage that process of potentially providing, and I call it appropriate assistance that you'd expect a registry to provide, to assist someone to actually provide the information needed, prescribed information needed to actually institute an application? Could you give us any background in relation to that?
I might defer to Ms Haddad on that.
Thank you.
Sabeth Haddad, Chief Lawyer, Administrative Appeals Tribunal. It depends what stage in the process they're at. So they'll get a notification letter from the department with their decision that advises them of their review rights. The Department of Home Affairs is required to do that under the Migration Act. I understand they have availability or access to the translation and interpreting service, the telephone service, for language issues.
Sorry to interrupt. Sorry to interrupt. Is that service within the AAT or is that service within the department?
I believe the department manages that service.
Right, okay.
We use that service as well. So applicants who come to us are advised, and in fact potential applicants, that if they need interpreting assistance, that they can phone that number and it will be provided free of charge.
Okay. So what happens if someone is having all sorts of difficulty lodging an application, instituting the process? They're all at sea in terms of trying to initiate this process. What does the AAT do practically in terms of trying to provide what I will call the sort of service you might get at a Supreme Court registry if a member of the public who's self-representing comes along and wants to issue a writ, right? What does the AAT do practically to try and provide assistance, if anything?
Well, I guess that would depend on whether we were aware that there was an issue.
Okay, so let's assume I ring you, I'm in a detention cell, I ring you, I want to make an application, I have no idea how to do it, can you help me? What do you do?
Well, we have registry officers that will respond to queries, but exactly what they would say I would have to take that notice and get back to you.
Could you take that? My time's running out, but if you could you take that on notice? Because I am interested to understand to what extent the AAT perhaps receives an application that might be deficient in terms of prescribed information, but on the face of it, the intention is clear that someone is trying to institute a process. I'm keen to understand if there are any protocols that the AAT has in order to reach out to them or to try and assist them to exercise their rights.
Yeah, we can take that on notice. It would depend on deficiency because there is a concept of substantial compliance with the form that applies, but again, it would depend on the particular circumstances, but we can get that back to you.
And to the extent you can, and I don't, obviously you can't provide individual case details, but to the extent you can anonymise that and provide examples of the sorts of things you do, or just assist me to understand how this all works in practice, given the very short appeal time.
Yes, Senator.
Okay, thank you. Thank you, Chair.
Thanks, Senator Scarr. Senator Shoebridge, you have the call.
Thanks, Chair. Well, Senator Scarr's covered some of the ground that I was trying to thought might be useful with the AAT. The government says this is about clarifying matters where there's ambiguity and clarifying them to strike out a bunch of matters, to be clear, but clarifying matters to where there's ambiguity about whether or not an application has been validly made in the migration space. I think Senator Scarr was asking you if you had any data on whether this is an issue for you. Do you know if in the last couple of years, 3 or 4 years, there have been a number of applications purported applications or applications where you were trying to work out, had the application been validly made, had the information been provided? Is this an ongoing issue in the AAT?
I'm not sure I entirely understand the question, Senator.
I can rephrase it.
Yes, sure.
To make clear. The government has said, well, you have the Miller case, and are you aware of the Miller case, Ms. Haddad?
I am, Senator.
And that means that must may not be must. There may be circumstances where even though the law says something must be provided, such as a statement of reasons, that doesn't necessarily invalidate an application?
In the context of the particular legislative scheme, Senator.
Yes.
So the difference being that the Migration Act already has what's been found by the courts on numerous occasions to be a distinct intent to preclude jurisdiction if the requirements in Section 3471 aren't met. And that's done through Section 3481.
Yes, but
which hasn't changed.
Yeah, I don't. I'm relying upon what a series of submissions have said and what a number of legal commentators have said, that and indeed what the department have said, that these changes are informed by the Miller decision. Did you hear that evidence from the department? These changes are informed in part by the Miller decision.
I heard that evidence, Senator. I can't speak for the department.
No.
But as far as I understand it, Miller is distinguishable in these circumstances because it's within the particular context of the AAT Act as it stands, and it's currently distinguishable from the Migration Act because of the provisions like Section 3481, and that provision hasn't changed.
Yeah.
So I guess what it does in that sense makes clear that it doesn't apply, but it doesn't apply as it's currently drafted as I read it.
Okay. So to come back to my earlier question, the government says that these changes will provide essential clarity so that you know when an application is made or not made, and they say that clarity is beneficial. Did you hear them say that, or words to that effect?
Yes.
Yep. I'm asking you, under the current law, are there any matters that you can point to, or is there a pattern of applications you can point to, or purported applications where you don't currently have that clarity in the migration space?
I think that the clarity issue is perhaps more one for applicants.
So I'm asking you...
We deal with these issues on a daily basis.
Mm-hmm.
So we understand the requirements around fees, around standing, around reviewable decisions, around time limits,
So
around approved form.
So the government...
That may not be apparent to applicants.
Well, the government says this is going to provide greater clarity. I'm asking, in practice, what will that mean for your tribunal? Is it going to change anything in practice in terms of clarity? Are there a bunch of cases here that you're going to look at differently as a result of these changes?
In practice, I believe it's a continuation of the current position.
So
People believe that Miller affects it. This perhaps provides clarity. I don't believe Miller affects it.
But if an applicant would have had the benefit of Miller, but for these changes, and I hear you say it's distinguishable, these changes unambiguously say that Miller doesn't apply.
It's a bit hard to comment in the hypothetical, Senator.
Well, these changes in 3482...
yes, but 3482 have to be read with 3481.
Correct. And taken together, particularly the changes in 3482 that says if such an application is not properly made, the ART must not review the decision, and then states that for it to be properly made, it must have the prescribed information, and then, to be entirely clear, says the ART must not review or continue to review a migration decision, etc., in other circumstances. But it unambiguously shuts the door on any Miller argument, doesn't it?
If you want to take it that way, Senator, but I think that 3481, as it's been interpreted by the Federal Court for the last 20 years, does the same thing.
Yes, but I'm asking about this amending bill, and this amending bill...
The amending bill puts it beyond doubt, if you want to put those words before.
Puts it beyond doubt.
But 3481 uses the same language, just in the alternative, that to have jurisdiction, to have a valid application, you must meet the requirements of 3471.
The current 3481 says, subject to subsection 2, if an application is properly made under section 347 for review of a Part 5 review decision, the tribunal must review the decision. It's a positive requirement on the tribunal.
That's right, and that has been read by the courts to say that sets the threshold and requires for the tribunal to take jurisdiction, that the requirements of 3471 are met.
Yes, but the the new 3482 says is, rather than a positive statement about when the tribunal must review the decision, it's a negative statement about saying you must not review the decision.
Yes, it puts beyond doubt, but it doesn't change the position.
Well, it's informed by Miller and intended to shut the door, as we heard from the department.
I can't comment on that, Senator, but all I can say is that the law has been interpreted in the same way for an extended period of time. These are provisions, these requirements. I understand the question that was asked before of the Attorney General's Department. These requirements have been in place since the mid-1990s.
Under, you say
CNT1.
Federal Court interpretations of 348.
That's correct, Senator.
Yeah. And I assume it was a...
We're going to share the call in a minute, just to let you know.
And it's my understanding, I could be wrong, was Miller in the original jurisdiction of the High Court, or is it reviewing a federal court matter?
It's reviewing a federal court matter, but it was an appeal under the AAT Act. And an application made under Section 29 of the AAT Act, not an application made under the Migration Act.
And I can't remember if it was it appealed by the applicant or was it appealed by the department? By the minister?
By the applicant, Senator.
Yeah. And so it overturned the federal court interpretation, the prescriptive federal court interpretation, correct?
At first instance.
And had that and it's sometime since I read Miller, and I didn't ever to read the original jurisdiction, but did the original decision make reference to the line of authority under 3481?
I can't comment on it, Senator. I'd have to familiarise myself with it again.
All right, no, they're my questions. Thanks, Chair.
Thanks, Senator Shoebridge. Senator Ghosh, you have the call.
Thank you, Chair. I'd like to ask some questions about fees first. Are protection visa applicants charged upfront fees to seek merits review under the current arrangement?
No, they're not, Senator.
Okay. And under the transition to the ART and including in this bill, will they be required to pay any upfront application fees once the bill has passed, assuming it does?
No, Senator.
And where an applicant for a review of a migration decision is struggling financially and even post the decision, does the ART or will the ART have powers to vary the fee that they're required to pay?
So the regulations in that sense remain unchanged, Senator. Applicants, say for a migration decision, can request a fee reduction, 50%. And the situation currently is that they must pay at least 50% of the fee before the prescribed period ends. That situation isn't going to change as we interpret the legislation, Senator. That's at least 50% if they, sorry, I should clarify, Senator, at least 50% of the fee if they also lodge at the same time a request to have the fee reduced.
May I ask, have you been listening to the earlier evidence from the refugee advocates and then also the Attorney General's Department? No obligation to, but I'm just curious.
Parts of it, Senator. I had some buffeting problems with the video, so I didn't catch all of it.
Oh, don't mention that.
One of the it seems, and I'm sorry, I'm using your words again, Senator Scarr, disconnects that appears to exist in the two sets of evidence relates to the current system of having a prescribed form as against the new system of having prescribed information and documents that will be required. And at the heart of that appears to be a concern around whether the new system will be more or less simple or accessible for applicants for review. Do you have a perspective on that or thoughts on that question?
Well, the information that's required or the alternative, the document that's required under the new system is information we currently ask for in the approved form. So the approved form is not just the form itself, but obviously the contents as well. So we ask a series of questions in that form, and it's designed to for us to get enough information really to process the application and also to obtain the necessary files from the Department of Home Affairs. The current forms are, I believe they range from around 7 or 8 pages upwards, depending on whether they're for a review of a migration decision or a review of a protection decision or whether the applicant's in detention. So we ask for that information already, as well as a bit more information.
And the new regulations, as suggested by AGD, would merely require a yellow post-it note, which is giving my IT department heart palpitations.
They're laughing, Registrar. They're laughing.
But we will accept it, Senators.
That's clarity.
So can I unpack that a little bit, Registrar? That seems to suggest that it's that the issue you're raising is that in fact the proposed change is to accept less formal information or less perhaps technical or formal ways of submitting the same information. Is that right?
just refer back to what the department said, Senator. If you're looking at, as my colleague said, a 14 to 19 page application form compared to providing a letter that merely identifies yourself, provides contact details and a brief outline of what you're appealing against or seeking relief or review of, would think that that is somewhat more simplified than the form that's prescribed at the moment. And I think it does make, I think that does make it more accessible for an applicant.
I think that's the extent of my questions, Chair. Thank you very much, and thank you to the witnesses for the clarity of those answers.
Well, thank you very much, Senator Ghosh. We do have a stop at 4:30, and I've got a bit to go through before then, so I might thank the AAT for joining us today and wish you well on the next. How many weeks did you say? A week and a half?
1 week and 2 days, Senator.
1 week and 2 days. Okay, well, it's going to be a big 9 days for you. So we wish you well and thank you for appearing in front of the committee at such a busy time for you and your staff.
Always a pleasure.
Thank you very much. I just need to seek a motion from members of the committee to accept the tabled documents from today's proceedings. We have one tabled document. I think Senator Scarr, you're happy to move that way.
I'm very happy to move that way.
It's your document.
Thank you very much. Yeah. I'll also just seek a motion around the date of return for questions on notice. The Secretary suggested the 16th of October 2024 for questions on notice to be returned to us. I think that should give people enough time.
I'm very happy.
Very generous time.
It is very generous, Chair. It must be our Secretary's influence. I'm very happy with that.
Thank you very much. Well, that concludes today's proceedings. The committee has agreed to answers to questions on notice at this hearing should be returned by close of business the 16th of October 2024. I want to thank all witnesses who have given evidence today to the committee. I also want to thank broadcasting, particularly for getting us through those first 15 minutes. I apologise again. And the Secretariat for assisting us today. I now declare the hearing adjourned. Thank you, everyone.
Thank you.
Thank you, Chair.